Community Property Essay Rules. General Community Property Rules, Quasi-Community Property Concept. California is a community property state. A married couple is seen as forming a marital economic community, MEC, and property acquired by the couple, or either spouse during the MEC, which exists from time of valid marriage until the earlier of permanent separation, which may be effected unilaterally by a spouse by the communication of the intent to permanently separate together with conduct in conformity with such intent, or death, while domiciled in CA, is presumptively community property, unless it fits into specific categories of so-called separate property. Separate property includes property acquired by either spouse prior to, or for that matter after, the MEC, or during the MEC if, 1. By gift, inheritance, or bequest, 2. As income, issue, or rents on SP, or 3. By the expenditure of SP funds, i.e., property traceable to SP. California's system also captures so-called quasi-community property that would have been CP if the couple had been domiciled in CA at the time of acquisition. QCP is treated like SP until the death, or dissolution, of the MEC, when it is subject to treatment like CP. Default division upon death of spouse, right of decedent spouse to make will, surviving spouse rights to take against will. At death, in the absence of a valid will, i.e., decedent spouse dies intestate, CP and QCP owned by the decedent spouse will generally all be inherited by the surviving spouse. Anywhere from 1/3 to all of decedent spouse's SP will also be inherited by surviving spouse. It would be 100% if decedent spouse left no issue, or surviving parents, or issue of parents. But if as here decedent spouse was survived by one child, then surviving spouse would take 1/2 SP. However, a spouse may make a valid will in CA will probate a will that was validly made pursuant to the laws of another jurisdiction, where decedent spouse testator was domiciled at the time, even if the will would not be valid under CA law. However, if the will attempts to gift away CP/QCP owned by the surviving spouse can, at the cost of rejecting all gifts under the will, take against the will and claim all such CP/QCP, i.e., decedent testator spouse can only will away all of his SP and his 1/2 of CP/QCP without surviving spouse consent/acquiescence. Validity and effect of 2017 Codicil. Under California law, a will can be amended, revoked or otherwise modified in whole or part by a subsequent codicil, provided it is validly executed. A validly appointed conservator can make a will or codicil for a now disabled/incompetent person. Trust basics, characterization of trust res. A trust is fiduciary relationship in respect of property, where one party, the trustee, is given legal title to certain property by another, the settlor/trustor. The trustee holds the property subject to fiduciary duties for the benefits of certain beneficiaries who have equitable rights in the property. A trust requires trust property and ascertainable beneficiaries, an act of creation, including an inter vivos transfer to a trustee by the settlor with the intent to create a trust, and a trustee with duties, who can be selected by agreement between settlor and trustee, or trustee can be designated by court if settlor does not name, or intended person declines to serve as trustee. Trust must also have a valid purpose. Settlor can name self as beneficiary, and can reserve right to revoke trust. Providing income to a person, including settlor, during lifetime is a valid trust purpose. Rights of creditors to reach assets in revocable trust, rights of creditors to reach assets in trust after it becomes irrevocable. When settlor puts money or other assets into trust and reserves the rights to revoke, creditors of the settlor can generally reach these assets. However, a trust that is revocable inter vivos becomes irrevocable upon death. Valid will. A will is considered valid in California if it complies with the law of either I. California, 2. The state where the will was executed, or 3. The state of the decedent's domicile at death. H's will was executed in State X. Under the law of State X, which allowed only one witness to sign the will was valid. Community property law. California is a community property state. Under community property law, the marital economic community, MEC, begins with a valid marriage and ends with the death of a spouse, divorce, or permanent separation. Any property obtained during the marriage, as well as any labor and wages of the spouses during the marriage, is community property, CP. Property obtained prior to marriage, or after permanent separation, is considered separate property, SP. Property obtained by gift, inheritance, or devise before or during the marriage is also considered SP. Property that is obtained with SP only will also be considered SP, because a change in form will not result in a change in characterization. Quasi-community property, QCP, is any property obtained by the spouses during marriage while living in a non-CP state that would have been considered CP had the spouses been living in California. QCP will receive that classification on the death of the titled spouse or on divorce, prior to which the property will be governed by the law of the non-CP state. QCP will be divided on divorce just as CP is. However, once H died, the property became classified as QCP and will be treated as community property for the purpose of W's rights if she elects to take her CP law share instead of taking under the terms of the will. Joint tenancy. A joint tenancy is characterized as having 4 unities: unity of possession, unity of transfer, unity of interest, and unity of time. This means that for a valid joint tenancy to be present, the tenants must have the right to possess all of the property together, they must receive those interests in the same instrument of transfer, and in equal shares, at the same time. A right of survivorship can only be created by express language in the deed. Consideration is not necessary to transfer an interest in real property. A right of survivorship vests the entire interest in the property to the surviving tenant after the other has deceased. Electing under community property law. Under California intestacy law, the spouse takes an intestate share that includes the deceased spouse's 1/2 interest in the community property, in addition to the surviving spouse's own 1/2 interest in the CP, totaling to all of the CP. In addition, if the deceased spouse is surviving by one issue, parent, or issue of parent, the surviving spouse takes half of the deceased spouse's separate property. Spouse's homestead rights. In probating a will, a spouse can petition the court to allow for a homestead for the surviving spouse, essentially allowing the spouse to continue living in the family home. Special title presumption. On divorce or death of a spouse, property will be presumed to be held as stated in the title. This presumption can only be rebutted by clear and convincing evidence. In California, it must be rebutted by clear language in a deed or other document that indicates the spouse's intent to hold the property as not stated in the title, such as CP. 2017 Codicil. A prior will can be revoked in whole or in part by subsequent instrument, such as a codicil. By a conservator. If the testator does not have capacity to make a will, a conservator can make a will if ordered to do so by a court. A conservator has fiduciary duties towards the incapacitated person. An incapacitated person can nominate someone to serve as their conservator prior to becoming incapacitated. Liability for debts. The MEC is liable for debts of the spouses incurred both before and during the marriage. However, the SP of a spouse will not be liable for debts incurred by the other spouse prior to the marriage. Furthermore, in settling an estate, creditors are paid first, and any devises will abate proportionally to satisfy the testator's debts accordingly. Ability to reach trust. A creditor can reach the interest of a person in a trust if it is freely alienable, if the settlor retained a right to revoke the trust, or if the assets of a trust are subject to the demand of a current beneficiary. If her SP is also liable for the debts, such as if some of the debts were incurred for necessaries of life, or for the benefit of the community, the creditors could reach her interest because as a life tenant, she would be entitled to payment from the trust. Omitted spouse. If T married N and never updated his will after their marriage, and his will does not provide a gift for his wife, or evidence a specific intent not to provide for his wife, and the wife does not get a gift outside the will, such as an annuity, the wife is considered an omitted spouse, and she takes a share of the estate equal to what she would get if her spouse died intestate. Intestate. The intestate rules provide that a spouse receives all of her husband's estate if he died without issue or parents. If he died with one child/issue or parents, the spouse would take half his SP and all of the CP. If he died with 2 or more children/issue or parents, the spouse would get 1/3 of his SP and all of his CP. T died with 3 living children, so his omitted spouse gets 1/3 of his SP and all of his interest in the CP. Under these calculations, N would get $30,000, which is 1/3 of T's SP, plus all of the CP. As discussed above, since T died with more than one child, issue, and a spouse, the spouse gets 1/3 of T's SP, and the children get 2/3 of the SP. The 2/3 is divided equally, per capita to the children, or per capita with representation if any of the children predeceased their father and left issue. Independent legal significance. Start employees. The court will determine whether the employees are sufficiently identified in the will. The will refers to each person who is an employee of my company, start, at the time of my death. The court will find that these are facts of independent legal significance. T would have employed these people regardless of whether he wanted them to take under his will. Lapse and anti-lapse. Under California law, a beneficiary of a testamentary gift must survive the testator, or else the gift lapses, meaning it fails. If the gift lapses, the gift goes to the testator's residuary devisees, if any, and if not, it is distributed by intestate distribution. A testator's residuary estate is a gift of whatever is not specifically devised in his will to certain beneficiaries. California does have an anti-lapse statute. However, it only applies if the devisee is the kindred, blood relative, of the testator and the kindred leaves issue. Wendy was Ted's spouse, not his kindred. Therefore, the anti-lapse statute does not save her gift under Ted's 2001 will, and the separate property and community property devised to Wendy by Ted's will therefore lapses and will be distributed via intestate succession. Under California intestacy distribution laws, when as here, there is one surviving spouse and more than one surviving issue, here, Ted has 3 surviving children, the surviving spouse is entitled to the testator's 1/2 of the community property, so she ends up with 100% of the community property and 1/3 of the testator's SP. Omitted child. Just like the pretermitted spouse, California protects children who have been unintentionally omitted from a testator's testamentary distributions when the child is born or adopted after the execution of all testamentary instruments. Pretermitted children are entitled to their intestate share of the testator's estate, unless the face of the will indicates an intent not to do so. The child is provided for by a non-testamentary transfer, or all of the testator's assets are given to the mother of the pretermitted child when the testator has other children, with the indication that the mom take care of all the kids. Under California's intestate distribution laws described above, would mean that Carol is entitled to her share of 2/3 of Ted's estate, Nell gets 1/3, and all the children would share the other 2/3 of the SP. Starred employees acts or facts of independent significance. To take under a will, the beneficiary must be ascertainable. Usually all of the material terms of the will must be within the will itself, and extrinsic evidence is not allowed to supplement the will provisions. Generally, the court will not admit extrinsic evidence to probate a will due to fear of fraud. However, a gift to a group of individuals to be determined upon the death of the testator can be a valid gift. Under the theory of acts or facts of independent significance, the court may use external facts to fill in the gaps of a will if the external facts would be in existence regardless of the will. In other words, the existence of the extrinsic evidence is not testamentary in nature, and therefore does not have the same concern of fraud. Intro. California, CA, is a community property, CP, state. There is a community presumption, meaning that all property acquired during marriage is CP. This includes wages of either spouse and labor of either spouse during marriage. There are areas of separate property, SP, 1, property acquired before or after marriage, 2, property acquired during marriage by either spouse through gift, will, or inheritance, 3, property acquired from SP funds, and 4, profits, rents, and issue of SP. The burden is on the spouse opposing SP to defeat the CP presumption. Courts use the source rule to determine the character of property by tracing the source of funds used to acquire the property. Marital economic community. The marital economic community, MEC, begins at marriage and ends at death of either spouse, divorce, or with the intent of either spouse to not resume the marital relationship coupled with conduct indicating that intent. If spouses maintain the facade of marriage, the MEC has not ended. Property division. Generally, on divorce, CP is divided equally in kind, meaning on a per item basis, not in the aggregate, unless a special rule requires deviation from the equal distribution requirement. Earning power is not generally not considered, other than considering spousal support or debt. Upon divorce, each spouse is entitled to their own SP. Upon death, one spouse's CP inures to the other spouse, such that the surviving spouse ends up with 100% of CP. The surviving spouse is entitled to at least one-third of decedent spouse's SP, depending on how many, if any, heirs or issue the decedent left behind. Note that all CP is divided equally between the spouses. Thus, even if property below is awarded CP, it is still split between the two spouses upon marriage, with the exception of personal injury funds. Retirement pension. To determine the character of pension, courts use the time rule. Courts consider the amount of time the spouse worked during marriage to get the pension divided by the amount of time total the spouse worked to get the pension. The rationale for the formula is that spouse's labor during marriage is CP, and any funding earned from spouse's labor is CP. As stated above, the pension plan monthly installments are W's SP, because she worked as an accountant for many years prior to the marriage and thus, under the time rule, none of her labor during the marriage, CP labor, was used to earn the pension. Transmutation. Spouses may alter the character of assets during marriage with an agreement known as a transmutation agreement. A transmutation agreement may alter the character of CP to SP, SP to CP, or one spouse's SP to another spouse's SP. A valid transmutation agreement must be in writing, accepted by the adversely accepted party, signed, and expressly state that ownership of the property is being transferred. One exception to the writing requirement is gifts of personal property given by one spouse to another spouse that are not substantial in value and used in the home. As stated above, wages earned during marriage by either spouse are CP. The fact that such wages are deposited into an account in the sole name of just one spouse does not alter the character of the funds. CP funds used towards SP. When CP funds are used towards SP property, the character of the property does not change. Rather, the community gets a pro rata ownership share in the property. Courts use the principal debt reduction method to discern the community's ownership share in the property. The community is entitled to the amount it expended to feather the nest of CP. Additionally, the community is entitled to the pro rata increase in value of the property as to its pro rata ownership share. As such, the townhouse is SP, and under the principal debt reduction method, the CP will receive a pro rata share as follows: amount of CP funds expended on paying down the debt divided by the total amount of SP and CP money used to pay off the debt x the increase in value. Furthermore, the CP is entitled to the funds expended on paying down the debt from H's account. Debt lender primary intent theory. With regards to the mortgage, the lender's primary intent, when giving the loan, determines the character of the loan. If the lender looks to SP as security, the mortgage is likely SP. However, if the lender looks to the spouse's standing in the community or CP property as security, the loan is likely CP. Here, the loan was given before marriage. Therefore, the mortgage is entirely SP. Upon divorce, W will be responsible for the mortgage unless justice requires otherwise. Commingled funds. However, commingling SP and CP funds does not alter the character of either spouse. When CP and SP funds are commingled, the burden is on the spouse claiming that property acquired with funds from that account is SP to show that SP funds were used to acquire the property. W can satisfy the burden using two methods of accounting: 1. Direct-indirect out method, and 2. The exhaustion rule. Under the direct-indirect out rule, the spouse claiming SP must show that there were sufficient SP funds in the account, and that the spouse had the intent to purchase the asset with SP funds. Alternatively, under the exhaustion rule, the spouse claiming SP must show that all the CP funds were used in the account, and all that was left in the account was SP. Under the family expense presumption, expenditures for community items, such as living, rent, food, etc., are presumptively made from CP. If there are not adequate records and commingling occurs, it is presumed the SP funds used for family expenses are a gift to the community. Wilma's pay from her accounting work, which is CP, was not enough to cover all of their expenses, and the monthly pension installments, SP, were used to pay the rest of the expenses. Under the exhaustion rule, W has a strong argument that only SP funds were used to purchase the motorboat because the CP funds were exhausted, shown by the fact that Wilma's accounting work was not enough to pay for their expenses. This means that inevitably Wilma's separate property was used to pay for the living expenses. Under the family expense presumption, it is presumed that CP was used first to pay for the family expenses, and that all the funds left to purchase the boat were Wilma's SP. Personal injury award. Generally, all funds acquired during marriage are presumptively CP. With regards to PI settlement awards, if the cause of action arose during the MEC, the settlement award is CP. Although PI funds awarded from a cause of action that arose during marriage are CP, upon the divorce the court usually awards the funds exclusively to the injured spouse as SP. However, this exception is limited and applies only if those funds are not spent. The court will attempt to trace back the funds to determine that. Characterization of funds. From Harry's account, there is an issue as to whether the funds used to make the payments on the townhouse mortgage were separate property or community property. Generally, all assets acquired during marriage, including any income earned, is presumptively community property. The fact that the funds are placed in a separate account, not a joint account, does not change the characterization of the property. Proration Rule. Under the Proration Rule, when community property is used to pay an installment payment on separate property, the community gains an interest in the property. The community has a prorated interest in the property, calculated by the expenditure of community property towards the installment payment over the total purchase price. Family expenses presumption. There is a presumption that all family expenses are paid with community property. Any funds spent on household expenses exceeding the amount of community property is deemed to be a gift to the community. Exhaustion. A spouse can show that a purchase was made with separate property from a commingled account if they show that the community funds were exhausted, and the only remaining funds were separate property. Tracing. Tracing is available when you can directly trace a deposit of separate property into a commingled account to a subsequent purchase. Transmutation. A valid transmutation requires a writing signed by the spouse whose interest is affected, and must explicitly state that a transmutation in the form of property is being made. Personal injury award. Funds received from a personal injury settlement are community property if the cause of action arose during the economic community. Generally, personal injury settlement funds are community property. The court will, however, award the entire recovery to the injured spouse upon divorce, unless the money has been spent or the interests of justice require otherwise. End of economic community. The economic community ends when the parties intend not to continue marital relations and take action consistent with that intent. Intro. California is a community property state. Unless the parties have agreed otherwise in writing, all property acquired during the course of marriage is presumed to be community property, CP. Property acquired before marriage and after the marital economic community has ended is presumed to be separate property, SP. In addition, property acquired by gift, devise, or descent is presumed to be SP as well. To determine the characteristic of an asset, courts generally trace the property to the assets that were purchased. At divorce, all CP is equally divided between the parties, unless they have otherwise agreed in writing, orally stipulated to in open court, or an exception applies to the general rule of equal division of CP at divorce. A spouse's SP remains his or her SP at divorce. With these general principles in mind, each property will be assessed individually. Property in joint form. In California, property that is held in joint form is presumed to be CP. Therefore, when H transferred his interest in the condo to W as joint tenants, the law will presume that he intended to gift the condo to the CP, and for each to hold as joint tenants with right of survivorship. When property that is held in joint form is to be divided at divorce, two statutes apply. First, in order for the transferring spouse to have an interest of ownership, it must establish that there was either a written agreement that he was to hold it as SP, or that the deed itself contains language that the property is only to be SP. Duty of good faith and fair dealing. However, H can argue that the transaction should be set aside because it is presumptively obtained through undue influence and, therefore, void. In the course of dealing with one another, spouses owe the same duties as those who are in confidential relationships. This duty imposes upon them the highest duty of good faith and fair dealing when the spouses enter into transactions with each other during their marriage. If one spouse gained an unfair advantage over the other in a transaction, the court will presume that the transaction was obtained via undue influence and, thus, invalidate it. The spouse who obtained the advantage will have the burden to prove that the transaction was entered into by the other spouse freely and voluntarily with full knowledge of all the facts relevant to the transaction and the basic effect of the transaction. Transmutation. A transmutation is an agreement by the parties that changes the form of ownership from CP to SP, or SP to CP, or one's SP to the other's SP. However, to be valid, there must be a written agreement signed by the party whose interest is adversely affected and expressly state that a change of ownership is to occur. The general exceptions to writing requirements do not apply here. The only exception is when a spouse gives a gift of a tangible item of personal property to the other spouse. Debt-lender intent theory. Each spouse has an equal right of management over CP and, therefore, has the right to individually enter into agreements to purchase property on credit, without the approval of the other. Determining whether a property purchased with a credit from a lender hinges on the primary intent of the lender, and where he was looking for assurances before giving out the credit. For example, if the purchasing spouse used his own SP for collateral for the credit purchase, then it would be presumed to be SP, because the lender's primary purpose for giving the loan was due to the collateral. However, where the lender relies on the purchasing spouse's good credit, the property purchased with that credit is presumed to be CP. This is because one's good credit, or reputation, as having good credit is community property. CP funds to pay SP. Where a spouse has acquired property before the marriage, or acquired property through inheritance, and then CP funds are used to pay for the principal of the property, the community estate obtains a pro rata interest in the property based off of the principal debt reduction due to funds paid from the CP. Marital economic community. The marital economic community ends when there is a permanent separation by the parties and an intent by one of the spouses to not resolve the marriage. The filing for a marriage dissolution is determinative evidence of such intent. Transmutation. One spouse may not gift themselves community property. In order to change the character of property from CP to SP, or SP to CP, there must be an agreement in writing signed by the spouse whose interest is adversely affected explicitly stating that the spouse intends and understands that she is altering the character of the property. Oral agreements will not be a valid transmutation. Title in joint form. A married couple who takes title in joint form when it is inconsistent with the nature of the funds used to acquire the property will be presumed to have intended the property as CP. Taking title in joint form with no indication that a spouse wanted to reserve a separate property interest creates the presumption of CP. Reimbursement. Assuming that the deed from Hal to Wanda is a valid transmutation, then at most Hal would be allowed reimbursement for his SP that was used to acquire the condo by the community. The reimbursement will be allowed without interest or apportionment of increase in value to the items. A court would likely use the value of the property at the time it became CP, which for the condo was $250,000. Hal would be reimbursed for the $250,000 at divorce, and the remaining value of the condo would be divided in kind 50/50ths between Hal and Wanda. Fiduciary duties of spouses. Spouses owe one another the highest duty of care, and are fiduciaries to one another. If one spouse breaches her fiduciary duty to the other, and takes advantage of that spouse by gaining an interest financially, or in an asset, then the non-breaching spouse may be able to set aside the conveyance on those grounds. Equal RT of management. Each spouse has an equal right to manage the assets of the community, and keep the other spouse reasonably informed as to the financial situation. Tracing. One spouse may not appropriate CP to themselves by simply taking title to the property in their name alone. When both SP and CP are used for the purchase of an asset, the funds used to acquire the property will be traced to their source, and the property will be characterized in accordance with funds used for acquisition. Property that was initially SP will continue to be SP even if the SP is exchanged or sold, and the form changes. Credit intent of the lender. The credit, goodwill and reputation of a spouse belong to the community during the marriage. This also includes credit scores. A loan taken out during the marriage is a community debt unless it can be shown that the lender in determining whether to loan one spouse the money relied solely on the borrowing spouse's separate property for repayment. The fact that a lender relied on one spouse's good credit is not the determining factor, because good credit of one spouse belongs to both spouses as community property. Repayment of loan W joint ACCT $. Wages and earning of a spouse are community property if earned during the marriage. Here Wanda and Hal were putting their earnings into a joint checking ACCT, which was used to pay off the motorcycle loan. Because CP was used to pay off half of the motorcycle loan, the community owns a half interest in the motorcycle. Conclusion as to the motorcycle. Hal owns the motorcycle as 50% SP, because half of the purchase price can be traced to his SP inheritance. The community owns the other 50% interest because community property was used to obtain the loan and pay off the loan. Gift exception to transmutation. There is an exception to the requirement that all transmutation be in writing. The exception is for gifts given to one spouse that are for that spouse's personal use, and that are not substantial in value. Conclusion as to the van. If a court finds that by purchasing the van and titling it in Hal's name alone that Wanda intended a gift of her CP to Hal SP, then the van will be considered Hal's SP at divorce. Otherwise, by tracing the funds to the CP checking account, the van will be deemed CP. Source: the facts tell us that Wendy, W, and Hal, H, purchased the family house during their marriage. However, we don't know what funds were used to purchase the house. If W's or H's earnings were used, or a combination thereof, and those earnings were earned during the course of the marriage, then the house would be CP, because spousal earnings are CP to the extent they're earned during the marriage. However, if one spouse partially used inheritance money, or other SP acquired before the marriage, then that spouse would likely have a SP interest in the home to the extent SP was used to purchase it. Pre-1975 title of home in woman's name. There is no evidence that the house was put in only one spouse's name, suggesting that the house was the separate property of that spouse. Pre-1975, if the house was in W's name, the married woman's special presumption would operate to render the house, or the share of the house in W's name, W's SP. Title taken in only one name, anti-lupus. Modernly, if title was taken in only one spouse's name, a court would not likely hold that to be conclusive evidence that the house was that spouse's SP absent some manifestation by the other spouse that the house was intended as a gift. If H and W took title to the house as joint tenants with a right of survivorship, each would have a half SP undivided interest in the whole during life. On death, the form of title would control. On divorce, under CA's anti-Lucas statute, the house would be treated as CP, with a right to reimbursement for any SP used by either spouse to improve the home. Community responsibility for debts of one spouse. All debts incurred by either spouse prior to or during the course of marriage are community debts. Tort obligations are incurred when the tort occurs, not when judgment is handed down. Thus, any obligations arising out of H striking the pedestrian were incurred when he hit the pedestrian. Marital economic community. The marital economic community begins at marriage and terminates upon permanent physical separation, when at least one spouse has no intent of continuing the marriage. Tort liability, community property. When a tort is committed during an activity for the benefit of the community, the debt will be satisfied first by CP, then by the tortfeasor's SP. The non-tortfeasor spouse's SP is not subject to the debt. When a tort is not committed during an activity for the benefit of the community, the debt will be satisfied first by the tortfeasor's SP, then by CP. Again, the other spouse's SP is safe. Reimbursement to the community. To the extent any CPI.E, the house is used to pay any obligation arising out of H's accident with the pedestrian, the community may be entitled to reimbursement from H. Where CP is used to pay an obligation arising out of spouse's tort that was committed not during an activity for the benefit of the community is entitled to reimbursement for that payment if the tortfeasor's SP was available to pay, or if the order of payment was not followed. Distribution of debts on divorce. At divorce, community assets are generally divided under the equal division rule I.E. Each spouse gets one half of each community asset in kind. However, a judge has more discretion as to the allocation of debts at divorce. Typically, a judge will allocate a tort debt to the tortfeasor spouse if the tort was incurred not during an activity for the benefit of the community. Equal management. Each spouse generally has equal rights to manage community property. This includes the right to sell and encumber community property. However, with respect to real property, one spouse may not encumber community-owned real property without the other spouse's consent. If one spouse, without consent, sells or encumbers community real estate, the non-consenting spouse has the power to void that transaction within 1 year. Post-marriage debts. Therefore, W's interest in the family home is not subject to payment for the additional reason that CP is not liable for H's separate post-marriage debts. Community property and separate property. California is a community property, CP, state. Property acquired during a valid marriage, while domiciled in CA, is presumed to be CP. Property acquired before marriage, or after permanent separation, is presumed to be separate property, SP. Property acquired during marriage through gift, bequest, devise or descent is also presumed to be SP. Under the source rule, tracing will be permitted to determine the source of the funds, and therefore the character of the asset as CP or SP. Upon divorce, CP will be divided equally in kind unless some special rule requires deviation from this equal division, or the spouses agree otherwise in writing or orally in open court. Prenuptial Agreement. Spouses may deviate from the community property presumption by agreeing that their salaries, for instance, which normally would be a product of community labor during the marriage and thus CP, be SP. They may do so before the marriage through a written prenuptial agreement. Prenuptial agreements must be voluntary and not unconscionable. A court will find a prenup to be unconscionable if the terms are unfair, or if a spouse did not know the extent of the other spouse's property before signing the agreement. Additionally, prenuptial agreements must be in writing. A court will find that a prenup is not voluntarily executed if a spouse is not represented by counsel before signing the agreement. In order to rebut the presumption of involuntariness without counsel, the spouse not represented by counsel must be advised to seek the advice of counsel in writing and must waive that right in writing, and if she does waive that right, she must be allowed 7 days between the presentation of a prenuptial agreement and the signing of it, and she must also write, in a separate writing, that she understands the rights she is giving up, and from whom she received the information regarding what the extent is of her spouse's property. Title presumption. Property titled in one spouse's name alone is not presumably SP in CA. General CP presumption. Assets acquired during marriage are presumably CP. Tracing, source rule. Under the source rule, a court will trace the assets used to purchase a particular property during marriage to determine its character. Transmutation. Spouses may alter the character of property from CP to SP, or from one spouse's SP to the other spouse's SP, or from SP to CP. After the easy transmutation period ended, courts now require transmutations to be in writing, and consented to or accepted by the spouse whose property is changing in nature, and the writing must explicitly state that a change in property is occurring. An exception to the writing requirement for valid transmutations is when a gift of a personal nature is given from one spouse to another, and that gift is used primarily by the recipient spouse, and is not substantial in nature, taking into consideration the financial situation of the couple. Jointly titled property CP presumption. In CA, when title to property is taken in joint form, there is a presumption that the character of the property is CP unless in the title document, or elsewhere it is stated that a portion, or all of the property, is to be reserved as an SP ownership interest. In this case, under Lucas, a court will not allow tracing to determine the funds used to purchase a jointly titled home through the source rule, and the property will be deemed CP. However, this joint presumption does not apply to bank accounts. With bank accounts, a court will allow jointly titled bank accounts to be traced to determine the source of funds and how it should be characterized. Rents, issues and profits. The rents, issues, and profits of CP will be CP, and the rents, issues, and profits of SP will be SP. Equal management and control. Each spouse has equal ability to manage and control CP. However, this is subject to certain limitations. For instance, a spouse may not sell or encumber personal property in the home, or CP clothing belonging to either spouse or children without consent of the other spouse. Gifts of CP. Moreover, spouses may not make gifts of CP without the written consent of the other spouse. A spouse may void the gift upon finding out about it. Breach of fiduciary duty. Spouses owe each other fiduciary duties similar to those of business partners. They owe each other the highest duty of good faith and to avoid self-dealing. End of the economic community, permanent separation. The economic community begins during marriage and ends upon permanent separation. Permanent separation is understood through physical separation plus an intent not to resume the marital relationship. Separate debts of spouses. Debts acquired after permanent separation are SP, and the debtor spouse will be liable to his creditors for such debt incurred. Necessaries of life. Despite the general rule that debts incurred post-separation are the SP debt of the debtor spouse, and that spouse only will be liable for that debt to creditors, there is an exception for the necessaries of life and debts incurred on their behalf post-separation, but before divorce, because of the duty spouses owe to each other to take care of each other during marriage. General principles. California is a community property state. Property acquired during marriage is presumed to community property, CP. Property acquired before marriage or after permanent physical separation is presumed to be separate property, SP. In addition, property acquired by gift, bequest, or devise is that spouse's SP. The character of property is determined by tracing back to the source of funds used to acquire that property. At divorce, each CP asset is divided 50/50ths in kind, unless a special rule requires deviation from the equal division requirement, or if the spouses agree in writing or by oral stipulation in court. Each spouse's SP remains that spouse's SP. Characterization. Property acquired during marriage is presumed to be CP. A spouse can rebut this presumption by tracing back to the source of the property and showing that SP was used to purchase the property. Transmutation. Spouses can change the character of any asset from CP to SP, SP to CP, or from one spouse's SP to another spouse's SP. This is called a transmutation. To be valid, there must be an express declaration in writing that is signed or assented to by the spouse whose property interest is adversely affected. The writing must expressly state that a change in the property ownership is being made. Exception: gift of personal nature. A transmutation is not necessary to change the character of an item when there is a gift from one spouse to another of an item of personal nature. For this exception to apply, the item must be of a personal nature, used primarily by the spouse who was gifted, and the item must not be substantial taking into account the circumstances of the marriage. Personal injury award. The character of a personal injury award is determined when the cause of action arose, not when the spouse receives a settlement or judgment. If the cause of action arose during marriage, then the personal injury award is CP. If the cause of action arose before marriage or after permanent physical separation, then it is SP. Division at divorce, personal injury. The general rule is that each CP asset is divided 50/50ths in kind at divorce. One special rule that requires deviation from the equal division requirement is for personal injury awards. At divorce, a personal injury award will be awarded entirely to the injured spouse unless the interests of justice require otherwise. The stock option profits. The rents, issues, and profits of community property are community property. Stock options get special treatment under the rules when the stock options are granted during the marriage, but are not exercisable until after the marital community ends. It first must be determined when the marital community ended. The community interest in stock options depends on which formula is used. Which formula is used depends on what the intent of the employer was in granting the options. If the employer's intention was to reward the employee for past services, then the formula is, the numerator is the years that the employee was married until the economic community ended, and the denominator is the years the employee was married until the options became exercisable. The community gets a larger percent under this formula, because community labor is community property. If the employer's intention was to grant the options as an incentive to continue working for the company, the formula is, the numerator is the date the option was granted until the economic community ends, and the denominator is the date the option was granted until the date the options became exercisable. The fraction represents the community property interest. Reward for past services. Here, when Wendy was hired in 2010, she was married to Henry. Henry and Wendy permanently separated in 2013, which is when the economic community ended. Thus the numerator is 3. The options became exercisable in 2014, so the denominator is 4, 2010 to 2014. Thus, the community interest in the stock option profits would be 3/4. Incentive. Here, the options were granted in 2012, and the economic community ended in 2013. Thus, the numerator is 1. The options were granted in 2012 and became exercisable in 2014, making the denominator 2. Thus, the community interest in the stock option profits would be 1/2. End of the marital community. The marital community ends when there is permanent physical separation and an intention not to resume the marriage. Intention not to resume the marriage by one spouse only is effective so long as it is communicated to the other spouse. Child support payments. Child support payments from a previous marriage are treated like a debt incurred before marriage. The CP is liable and the parent spouse's SP is liable. The other spouse's SP is not liable. The community is entitled to reimbursement for child support payments made with community funds to the extent that separate property was available and not used. A spouse's salary during marriage is community property. Management and control gift of community property. After January 1, 1975, both spouses to the marriage acquired the rights to equal management and control of the marital assets. Under the rules regarding the rights of equal management and control, one spouse may not make a gift of CP without the consent of the other spouse. When one spouse makes an improper gift, the other spouse has a right to set aside the gift. In this case, if Wendy were trying to contest the gift during the marriage, she could set aside the entire gift. However, at divorce, a spouse only has a right to set aside one half of the gift, because the parties each have a one-half interest in all CP. Property taken in joint tenancy. Property acquired by spouses during marriage in any joint form will be presumed to be community property at divorce. Transmutation. However, modernly a transmutation is not valid unless it is in writing, indicates that there is a change in the character of the property, and is signed by the adversely affected party. Anti-Lucas legislation. However, under the anti-Lucas legislation, for purposes of dissolution only, all property held jointly is treated as CP. This presumption can only be overcome by a statement in the deed that the parties intend to hold title differently, or a written companion agreement. Division of property at divorce. The general rule is that at divorce, CP should be divided equally in kind. However, the court can fashion other relief if necessary. In this case, since Hank evidenced an intent to give the house to Wendy, the court may allow Wendy to keep the house and just award Hank the value of one half of the house. Pereira. Under the Pereira formula, the court takes the initial investment of the spouse, multiplies it by a simple and arbitrary interest rate, typically 10%, and then multiplies that by the number of years the spouse worked in the business during the marriage. That figure is considered to be a rate of return on the initial investment, and is awarded to the spouse who started the business with her SP. The remaining amount is considered CP. Van Camp. Under the Van Camp formula, the court will calculate a reasonable rate of earnings for the working spouse and multiply that by the number of years the spouse worked during the marriage. This figure would then be awarded to the community as CP. The remaining funds would be considered SP of the spouse and attributable to standard increases in value to the business due to the market. In general, the court will use the Pereira formula when the increased value of the business was attributable to the work of the spouse in the business. In contrast, the courts will use Van Camp when the increase in value of the business is due to the overall market economy. End of MEC. The general rule is that marital community ends when there is physical separation of the parties with no intent to rekindle the relationship. Title in one name. Under California law, there is a form of the title presumption, which holds that the holder of record title to a property is presumed to be the true owner. Subject to CP acquired during marriage is CP. SP improvements to CP. However, modernly the general rule is that if a spouse contributes SP to a CP asset, he can be reimbursed for SP down payments, loan reductions, and improvements. Sale of CP. The general rule is that when disposing of CP real property, both spouses must participate in the sale and sign the appropriate documents. When a spouse disposes of real property without the consent of the other spouse, the injured spouse can set aside the sale if it is done within 1 year of the sale. Spouses' fiduciary duties to each other. Quasi-community property. If a married couple acquires property in a non-community property state that would have been community property had the couple been residents of a community property state, such items are considered quasi-community property (QCP) and are potentially subject to community property laws if the couple later moves to a community property state. During the marriage, the QCP is treated as SP of the acquiring spouse. However, upon divorce or death of the acquiring spouse, the QCP will be treated as CP and divided equally between the spouses. Upon the death of the non-acquiring spouse, the property will remain the SP of the acquiring spouse.